Rules of Court, Provisional Remedies, Rule 57, Preliminary Attachment, Section 1. Grounds upon which attachment may issue. At the commencement of the action or at any time before entry of judgment, a plaintiff or any proper party may have the property of the adverse party attached as security for the satisfaction of any judgment that may be recovered in the following cases. A. In an action for the recovery of a specified amount of money or damages other than moral and exemplary on a cause of action arising from law, contract, quasi-contract, delict or quasi-delict against a party who is about to depart from the Philippines with intent to defraud his creditors. B. In an action for money or property, embezzled or fraudulently misapplied or converted to his own use by a public officer or an officer of a corporation or an attorney, factor, broker, agent, or clerk in the course of his employment as such or by any other person in a fiduciary capacity or for a willful violation of duty. C. In an action to recover the possession of property unjustly or fraudulently taken, detained, or converted when the property or any part thereof has been concealed, removed, or disposed of to prevent its being found or taken by the applicant or an authorized person. D. In an action against a party who has been guilty of a fraud in contracting the debt or incurring the obligation upon which the action is brought or in the performance thereof. E. In an action against a party who has removed or disposed of his property or is about to do so with intent to defraud his creditors. Or F. In an action against a party who does not reside and is not found in the Philippines or on whom summons may be served by publications. Section 2. Issuance and contents of order. An order of attachment may be issued either ex parte or upon motion with notice and hearing by the court in which the action is pending, or by the Court of Appeals or the Supreme Court, and must require the sheriff of the court to attach so much of the property in the Philippines of the party against whom it is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless such party makes deposit or gives a bond, as hereinafter provided in an amount equal to that fixed in the order, which may be the amount sufficient to satisfy the applicant's demand, or the value of the property to be attached as stated by the applicant, exclusive of costs. Several writs may be issued at the same time to the sheriff of the courts of different judicial regions. Section 3. Affidavit and bond required. An order of attachment shall be granted only when it appears by the affidavit of the applicant or of some other person who personally knows the facts that a sufficient cause of action exists, that the case is one of those mentioned in Section 1 hereof, that there is no other sufficient security for the claims sought to be enforced by the action, and that the amount due to the applicant or the value of the property, the possession of which he is entitled to recover, is as much as the sum for which the order is granted above all legal counterclaims. The affidavit and the bond required by the next succeeding section must be duly filed with the court before the order issues. Section 4. Condition of applicant's bond. The party applying for the order must thereafter give a bond executed to the adverse party in the amount fixed by the court in its order granting the issuance of the writ, condition that the latter will pay all the costs which may be adjudged to the adverse party and all damages which he may sustain by reason of the attachment. If the court shall finally adjudge that the applicant was not entitled thereto. Section 5. Manner of attaching property. The sheriff enforcing the writ shall without delay and with all reasonable diligence attach to await judgment and execution in action only so much of the property in the Philippines of the party against whom the writ is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless the former makes a deposit with the court from which the writ is issued, or gives a counterband from which the writ is or gives a counterband executed to the applicant in an amount equal to the bond fixed by the court in the order of attachment or to the value of the property to be attached, exclusive of cost. No levy on attachment pursuant to the writ issued under Section 2 hereof shall be enforced unless it is preceded or contemporaneously accompanied by a service of summons, together with a copy of the complaint, the application for attachment, the applicant's affidavit and bond, and the order and writ of attachment on the defendant within the Philippines. The requirement of prior or contemporaneous service of summons shall not apply where the summons could not be served personally or by substituted service despite diligent efforts, or the defendant is a resident of the Philippines temporarily absent therefrom, or the defendant is a non-resident of the Philippines, or the action is one in rem or quasi in rem. Section 6. Sheriff Return. After enforcing the writ, the sheriff must likewise without delay make a return thereon to the court from which the writ issued, with a full statement of his proceedings under the writ and a complete inventory of the property attached, together with any counterband given by the party against whom attachment is issued, and serve copies therefrom on the applicant.